Very warm welcome to the Comparative Public Law Research Forum this Friday afternoon. Just to introduce our speaker, I'm delighted, absolutely delighted to welcome Dr. Leah Trueblood to deliver today's talk. Dr. Trueblood is based at the University of Oxford, where she is a fellow and tutor in public law at Worcester College. She was also a recent British Academy postdoctoral fellow at Oxford's Bonavero Institute of Human Rights. Dr. Trueblood first studied philosophy at the University of Alberta, and then she read for a law degree at the LSE before moving to Oxford for her DPhil. We are delighted, absolutely delighted, to welcome Dr. Trueblood to give this talk to us today about political parties, how to regulate them, how to control them, what to do about them. Just to say, there'll be time at the end for questions, and I'll sort of explain the process when we get there. But the idea will be that if you have questions, please just enter your questions in the chat, and then I will read them out to Dr. Trueblood. Okay, great. So without further ado, I'll hand over to Dr. Trueblood. Thank you.
Thank you so much. And huge thanks to Professor Hamid for the invitation. I'm a huge fan of his, and as he's published a scary amount of fabulous stuff recently, which I commend to all of you. And it's just a complete joy and privilege to see so many of you here on a Friday afternoon. You must be massive nerds like me. So I'm really excited to hear your thoughts about this work in progress. And I'm going to embarrass him too by giving a shout out to Alex Green, who's here, who taught me everything I know about legal and political philosophy. So although I don't know whether he wants me to say that, because we'll give him the credit and maybe we'll give him the blame. we'll pin stuff on him if it doesn't work. So what I'm going to do today is I say I'm going to walk you through a work in progress, and because I think the moves in this argument matter quite a lot, I'm going to walk you through the paper itself, and I would love to hear particularly things you don't find persuasive, because I think the tricky thing about what I'm trying to argue in this paper is in one sense, the claims I'm making are obvious, but in another sense, they're absurd. And that leads to juicy philosophical arguments. So let me share the PDF here, and then we'll, okay, very good. I'm gonna ask Professor Hamid, can everybody see? Is that okay? Is that working? Great. Okay,
Yes,
very
perfect.
good.
Yeah.
Excellent. Very good. Okay, let's see if I can get this working. Okay, so this is a paper which is connected to another paper that I've written, and together they're meant to be the spine of my very, very, very late next book, which is about how we think about how we regulate political parties. And so I'm gonna call back to it probably quite a bit today, but the first piece coming out in the Modern Law Review is really about the judicial side of regulating political parties. So how we think about how the common law controls or shapes their activities. And then today is really about the statutory side. And I see these as fitting together to think about political parties differently, really as political parties as groups that exercise state power. And I hope you're going to push me on that, and we're going to talk about that today. So this particular piece is about a paradox. So we have this paradox. So on the one hand, political parties hold, I think, this really privileged, powerful position in UK democracy, but parliamentary democracies generally. So they're the only groups with this opportunity to inhabit the state and form governments. But in spite of this, or perhaps because of this, legal scrutiny has been very hands-off. The approach has been, these are sites of political contestation, not legal contestation. This is the Venice Commission's strong recommendation, is although there's a great paper recently by Dixon and Landau showing there's a trend towards the constitutionalization of political parties worldwide. That hasn't been the case so much in common law democracies. And the rationale for this is clear. It makes sense. The thought is something like, look, political parties are a way of inhabiting the state, but that's not all they do. They're also a way of challenging the state. So if we say, look, political parties have to have internal processes that include one member for one vote, for example, then it might be undemocratic to include trade unions or specialist constituencies. So we're trying to strike a balance, right? We're trying to strike a balance between controlling the exercise of public power, but also making space for freedom of speech and association. And what I'm arguing in the book and in the papers is that balance hasn't been struck right. and what worries me is that because political parties are the kind of group can inhabit the state and exercise state power, they can monopolize public power. And without legal checks, I think, to shore up the political checks, then I'm worried that public power could be monopolized and democracy could collapse from the inside. So what I'm talking about in this paper, I'm going to propose 4 backstops or 4 statutory reforms, which I hope are going to prevent the monopolization of public power. So I'm worried about a scenario that goes like this. So let's imagine, so maybe let me say, let's imagine a process that goes like this. Let's imagine one of the political parties through its own democratic processes, the members vote on it. There's no question that it's contrary to the rules. And they say, look, the next prime minister isn't going to be selected by members of the Conservative Party, Labour Party, Liberal Democrats. It's going to be selected by 5 foreign billionaires. And the case law, I think, currently says that there's nothing public law has to say about that. There's nothing, that's fine. They say that's a matter of political contestation. If the consequences for a political party doing that are political, that if they think if people don't like that, they shouldn't vote for it. And what worries me about this, I think, is that I think that underestimates the degree to which the consequences of political parties being in power. So political parties are really powerful organizations because the leader of that party can automatically become the prime minister without, for example, without a general election. So we've got this really powerful side, but we've also got a vulnerability side. So political parties in the UK are what's called unincorporated associations. So the law doesn't say anything about how they have to organize themselves. They don't have to have constitutions. They don't have to have internal party processes. They don't need to chat. They don't need the rules of franchise, don't need to match those in the Political Parties Elections Referendums Act. So those who vote, for example, for the prime minister who voted for Liz Truss weren't the same people who voted in the general election. The rules don't have to line up. And so I say, look, there's this combination of power, the capacity to inhabit the state, but also vulnerability, this absence of regulation. And these come together, I think, to create good reasons why there should be greater legal regulation. So this paper proposes four sets of limits. And one of the things I'm really keen to hear your thoughts about, and Professor Hamid's thoughts about, and Professor Green's thoughts about, is what I've come quite late in the paper to wonder if these are requirements of the rule of law, or these came sort of bottom up as limits that I thought were important on political parties, but I wonder if there's a way to connect them through the rule of law, or that's what's doing the work here. So the kinds of limits or thoughts that I'm worried about are expanding freedom of information and data protection law. There was a bill about this which died when Rishi Sunak called the election, which would have addressed some of this. Freedom of information law, freedom of information doesn't apply to political parties. So requiring political parties to be clear about their internal processes, clarifying in law, moving away from this unincorporated association approach and saying more like the continental systems, this is the kind of group a political party is. And these are its legal rights and responsibilities. Expanding the power of the Electoral Commission to try to take election law questions out of a matter of political contestation into a 4th branch independent group. And then, how have I done this wrong? How have I done this wrong? Fascinating. Okay, how have I done this wrong? Here we go. I think this is what I've done. Okay, and then this is a little bit less surprising. Okay, here we go. Strengthening campaign finance laws to prevent corruption, and that's not too surprising. That's been an issue in the UK for decades. Okay, but one of the core philosophical moves is to say, look, that forming a government is it's a role obligation that parties play, and that comes with distinctive political and moral obligations, which give rise to good reasons to introduce these legal checks. So there are 5 things I'm going to do today. The first is I'm going to tease out that powerful but vulnerability tension. The second thing I'm going to do, and then what I'm going to do is I'm going to talk about the principles and why the thought has been that the principles that constrain parties have been political, and why I think conceptually these limits can't just be political, and practically they've got to be legal. And then what I'm going to do is put forward these 4 proposals about data protection, the Electoral Commission. And then what I'm going to do in response, I've given this paper a couple times to, people have been persuaded to varying degrees. And one thing that I've found is people really want to see the difference that it will or won't make in practice. So what I'm trying to do now in the 5th section of the paper is to say, well, here are some hypotheticals based on really challenging questions of regulating political parties in other jurisdictions, and what kinds of problems can my proposals prevent and what can't they prevent? So put differently, what is still going to be a matter of political contestation? What kinds of problems the law can't solve? And I think that's really the question for us today, is to what extent is the kind of scenario I gave you at the top where, look, a political party is captured by undemocratic forces internally or externally, to what extent is that a political problem or is it a legal problem? And I want to persuade you that it's at least in part a legal problem, to make sure the political pieces of that, the political checks that exist to prevent that can work properly. Okay, so the first on the vulnerability of political parties. So why this is a problem, why I'm worried about this. So it's incredible. There's this huge gap between the way political parties work in practice and what the law says about them, which is very little. So political parties are vulnerable institutions because the Political Parties Elections Referendums Act, the main body of law in the UK on election law, doesn't require any formal structure. So as I say, there's no requirements of internal democracy, no requirements of constitutions. The Unincorporated Association Act says there's a requirement of something called collegium, but this is an extremely light touch approach. And the purpose of the Political Parties Elections Referendums Act is really just to require political parties to register, but it only denies registration or registration of labels if it's offensive or obscene. It's really not, it's not meant to be telling parties how to conduct their internal affairs. Okay. And so, as I say, there's no kind of group that they need to be. So usually what political parties are these unincorporated associations. And that has all kinds of interesting implications. They can't own property. They can't enter into contracts. And so there's been calls for reform of unincorporated associations by the law commission, the joint law commissions, for decades. There have been 3 different reports recommending this. But this looseness, as I say, is a feature, not a bug of the system. And there are lots of good reasons for it. And I talk about 4 in the paper. One is that political parties are transient organizations. So people are joining and leaving them. Another is there's concerns about freedom of speech and association. A third is a worry that if you start legally telling political parties how to conduct their affairs, it makes it easier for. So most of the case law on political parties is about excluding people who've tried to enter political parties to undermine them from the inside, to say, well, I think the Conservative Party should be further to the center or further to the left, and so we're going to try to join to change it from the inside. So there are good reasons, is what I'm trying to say. There are good reasons for this hesitancy about regulating political parties. But I find it very odd to have a body of election law which says this is how we conduct general elections, but says nothing about internal party processes, even when that means the election of the prime minister. Now, to be clear, that doesn't mean I'm saying everything that we think about democracy and general elections applies in internal processes. Different groups are going to have different procedural standards. That's not what I'm saying. But what I am saying is that there are some forms of party organization that risk undermining the integrity of democracy as a whole. And that's what I was talking about at the top with that kind of foreign billionaires example. To me, that gets to something so fundamental that we need to find a way for the law to say something about that. And what we've also had in the UK is recently political parties stretching this. So the current leader of Reform, which is polling now comparable to the governing Labour Party, is a private company, or was till recently a private company. There was no election. The leader elected himself. And the thought has been, as I say, this is a political problem. If voters don't like it, they should vote for somebody else. And it is partly a member of democratic contestation. It absolutely is. Okay, here we go. So it absolutely is. But I'm saying, or what the requirements I'm doing, trying to put forward or trying to capture, are that in order for political contestation to work, there has to be transparency and independence within a regulatory system about how those processes work. Otherwise, it's not possible for voters to make up their own mind because political parties are both top-down organizations. They're people that can exercise state power, that can control and shape election law, that can shape political will. And because of that, they're top down and bottom up. They're a way of exercising state power, and so they should be constrained by the rule of law in the way that other exercises of public power are. And then I just give some examples of how there's evidence, I think, obviously people are innocent until proven guilty, but of members of UKIP now reform taking Russian bribes. So there's a huge amount of evidence. So I don't talk about so much in this paper, but in the judicial review paper in Canada, Australia, Europe, the United States, of interference in elections and political. And in some sense, there's nothing new about that. In some sense, there's nothing new about that. So it's necessary not to overreact or not to underreact, but I still think there are principled reasons to provide greater regulation of political parties. So as I say, there's a sort of obviousness and yet an absurdity. So in one sense, the phrase party in power is totally obvious, right? It's obvious in that a government in a parliamentary system does not arise in a vacuum. A prime minister is become in a parliamentary democracy becomes the head of government because they're the leader of a political party. So I think they're constitutively connected. But in another way, this kind of move I'm making is absurd. It's absurd because it's not thought to be the party that exercises state power. Once a party is elected and forms a government, that status as a party is thought to sort of fall away, and public law thinks it's benign or peripheral. And I don't think that's the right way to think about it. I think the role of forming a government comes with duties which are constitutive of that role, and that gives rise to hold them accountable and why the requirements of the rule of law should apply to them. So I walk through then the executive and the legislative consequences that I think arise from forming governments and why I think those should be understood to be exercise of state power. So for example, legislatively, through the control of the legislative timetable, deciding what becomes law at all. In addition, then obviously to passing law if there's a majority in the House of Commons, and then the executive power with all the prerogative powers that entails with respect, most notably, I think, to foreign affairs, and setting executive the policies of the executive agencies. And I guess what I want to say too is I don't think that's a bad thing. I'm not saying that's a bad thing. Governments are elected to do things. They should do those. I'm just saying that a logical consequence of exercising that power is power in a democracy cannot be legitimately exercised without limits. And that's what we're trying to do, is think about what kinds of limits are necessary, for example, to prevent conflicts of interest. And now one of the moves that I make too quick that I'd love to hear your thoughts about, but I want to unpack or think about, is this idea that this opportunity to form a government is a role obligation, or a special responsibility that a group of people can have, like an MP or a judge or the prime minister have. And I think the role of forming a government is morally and politically analogous, and that we can think more about the obligations that arise from that opportunity, that all opportunities to exercise powers or privileges come with obligations. And I think these special responsibilities are connected to what Weber says about the state, that the state has a directed coercive monopoly on the use of force. And I think that cannot be exercised legitimately if it's monopolized, right? There has to be contestation. And what the current view is that contestation can be political. And I think there need to be conceptual limits and then to shore that up, and then those come to effect practically through the limits I've put forward. So the current approach in law in parliamentary democracies is defined what Kaitan calls the purpose of autonomy principle. And the principle goes like this. The principle is we should leave political parties alone in a democracy to the extent they're content to be one party among many. They're prepared to be one player in a democracy among many. But he says this is a political principle. And he also advocates a political principle he calls the state separation principle. And I think these principles are excellent and important and helpful, but I think they have to be legal principles. When we think about other ways in which people and groups exercise state power, we wouldn't do so on good faith. We wouldn't say, well, as long as they're committed, in principle to being one party among many, that's enough. We don't think about it that way in democracy. We have all kinds of checks and balances. that exist, not because we assume people are acting in bad faith, but because power has to be limited in order to be legitimately exercised and to not be monopolized, so necessary for democratic contestation. So imagine, I think, the scenario that I've talked about happens in this paper. So you've got um, a foreign billionaire becomes prime minister. Um, as I'm saying, political parties, like all actors in democracy, aren't necessarily reliable narrators about whether or not they're committed to being one actor in a democracy among many. And I think that's what the law does, is it requires people to demonstrate, or it doesn't assume that power is going to be exercised benevolently. It holds it to account. We don't think all other kinds of executive power exercised just on the basis of convention. So there then I put forward, or I suggest, four reasons why I think these limits are conceptual. Um, so as I say, this is the key idea, that I think political power cannot be exercised without limits. And this idea that it can't be exercised without limits is a core commitment of the rule of law. Political parties sometimes exercise political power when they form governments. The role of political parties constitutive of forming a government. Therefore, the processes which bear on the role of forming governments, those which are governmental, should be subject to limits to ensure democratic contestation. If it wasn't the case, as I say, then public power could be monopolized and a political system would cease to be democratic. And I'm really persuaded by this idea that competition matters, not in a, I'm not persuaded by the market competition sense, but that this, if you've got, I really like this wonderful new paper in ethics by Shai Agman, who says, look, there are different kinds of competition. There's frictional competition and dualistic or parallel competition. But when if you've got one party setting the rules, then you don't have meaningful contestation in a way that's required for democracy, I think. So political parties, as I say, have this unique capacity to be in power. So they can only not mark their own homework, they can set their own homework, they can decide who marks homework in the future. So I'm concerned about, for example, voter ID laws, which privilege some political parties at the expense of others. So I think there's evidence that, as we say, that countries are moving away from the purpose of a autonomy principle, constitutionalizing parties. And as Dixon and Landau say in their paper, look, you're essentially assuming that judges are independent, otherwise this doesn't work. And I'm extremely sympathetic to that proposition. And there are risks and benefits to the approach. There are risks to the approach I'm advocating here and moving towards a site where there's more legal contestation of parties. But my pushback to this is usually to say there are risks to the status quo too. There are risks to the status quo, and that's what the power of the examples I'm trying to give is saying. We're going to talk about a case called Tortoise Media, which says, look, we don't know who's voting for prime minister. We don't know who's checking who's voting. And there's no way to find out. And I just don't think, I think that there's risks in finding that political parties are exercising public power, are exercising governmental functions, but there's risks to the status quo as well. Okay, so I put forward then I don't in the paper unpick, which I ought to do, the way in which this connects, the proposals I'm putting connect to the rule of law, and I'd love to talk to all you super smart people about that. But the four areas to me that it seems the law most needs to change first are on freedom of information, and the big recent case here heard by the Court of Appeal last week is this freedom of information. I'm probably almost out of time. Okay. Okay, sorry, there's an excellent message. Okay, which says, look, political parties aren't subject to the freedom of information clause, so they don't need to tell you who's voting, which to me just seems completely indefensible, that we know in great detail the demographics of general elections, very clear rules about who can't vote, but we don't know, the security services say we don't know who's voting for prime minister. And as I say, there were proposals of data protection in the Digital Information Bill that died, which are trying to allow people to understand the way in which they're being micro-targeted. And this is, I think, once we lose the idea that our political preferences are our own, we've lost something really important about democracy. Okay, so, have I done this? Okay, good. And then this is all too quick, but I really think, the election law is clear. The Law Commission have been clear for decades that election law is labyrinthine. It's completely impossible to understand. There's a real issue even with clarity, political parties just even understanding what the law is. And it's really dangerous because in elections, we don't want retrospective remedies. So we don't want to come to a political party after the fact and disqualify MPs or issue fines. We can't put the toothpaste back in the tube. So it's really important that we try to, in advance, clarify what election law is in order to have fair contestation in elections. And the part that I can't really get my head around, but I feel quite strongly about, is there has to be a way to separate some of the material pieces of election law out of, I don't love the word partisan, but away from partisan decision making into a fourth branch institution. So we're just, I think, quite lucky in the UK that boundary commissions, for example, have happened by convention rather than the kind of insidious manipulation of borders that you see in the United States. But that's the kind of question that I'm worried about. I'm worried about conflicts of interest. There are some kinds of decisions that it would be a conflict of interest for political parties to make because it would impact the results of elections. So I'm not saying that anything here is a substitute for democratic contestation. And in the paper, I give two examples of really difficult scenarios that my proposals aren't going to capture. So I was pushed back when I gave this paper in Canada on a case called Stevens and Conservative Party. So these are some members of a party and they're really upset because there's been a merger between some left-wing conservatives, some sort of center-right conservatives and some other conservatives. And so this is challenged through judicial review, whether this merger is allowed. And that's not the kind of, I'm not arguing that those kinds of, that the legal limit should exist to prevent those kinds of actions. But what I do think we're trying to do is get to a place where there's greater transparency so voters can be clear how their data is being used, be clear how processes are that they can be clear how those internal processes are taking place. And that was a big part of what was going on in that case, is that the political party just wasn't clear about how different members' votes would be weighted in those processes. So we can't prevent that, I think, through law. That is a political problem or a political challenge, but I think it's really important for this reason. It demonstrates the importance of transparency in internal party processes, and that's a legal requirement that's required for democracy, to people to have confidence in democracy, for there to be democratic contestation. The second really hard example, we've seen this in Romania, is the subsequent disqualification by the Electoral Commission of winners of general elections. And that's really, really hard and really scary. That's the nightmare scenario where you've got a political party captured by foreign countries. There's huge evidence of that. And then what an electoral commission does. So do they say, well, no, we've just accepted that our political system is being captured, and that's anti-democratic? Or do you say, look, we're going to disqualify these, and that just undermines the Electoral Commission itself? And when it gets to that nightmare scenario, there's nothing my proposals can do to help. But what hopefully they do is to strengthen campaign finance laws, to improve transparency, to make sure that it is clear to voters what's happening, and to prevent getting to those worst case scenarios. So those are the kinds of scenarios that I'm not suggesting in invalidating elections, but I am trying to emphasize that that's the kind of scary terrain that countries in Eastern Europe are getting to. We just hosted here in Oxford Eastern European countries who are really worried about this. And so I think trying to avoid that worst case scenario is something the law can and should do. So political parties play, I think, a really important role in democracy in at least two ways. They collect, as I say, political will to form governments, but they're also top down. They construct political will. They exercise state power. And I think that creates risks. And political parties could then monopolize this power such that it's impossible for democratic contestation to take place at all. And if that's lost, then I think the whole exercise is, I can't even say it. It's too grim to imagine. So I'd really love to hear, this is really a work in progress. I'm really trying to think through. I essentially have this instinct that political theory hasn't reckoned enough with the degree to which political parties exercise capital P state power and the limits, both judicial and statutory, that are needed to then give effect to the requirements of the rule of law. But the pieces of the paper still really needed to be knitted together. And I would just love, and I'd be so excited to hear your thoughts about that. And I'm so grateful for the opportunity and your attention. Thank you so much.
Wonderful. Thank you, Leah, for that fascinating, very rich talk. Just to say, we have, in terms of the question and answer session now, if you have questions, feel free to write them in the chat, and I can read them out. I just noticed Professor Green has, please go for it if you're unmuted, please.
Leah, thank you I mean, this is typical of all your work in that it's philosophically very sophisticated and so grounded in political and social reality. It's fantastic. I have a couple of brief clarificatory questions and then some friendly
Great.
addendums. So the
Excellent.
clarificatory questions, first of all, are on the formation of government. Is it the
Mhm.
forming of government that is an exercise of public power
Mhm.
precisely, or the functioning of government once formed?
Yeah, good.
Um, because some might say the forming of government is prior to an exercise of public power. That's all. I have no strong feelings, but that would be helpful. On the rule of law, are the desiderata you identify necessary elements of the rule of law in multi-party democracies, or are they just requirements of the rule of law as applied to the case of political parties? Because I wasn't quite clear on that. Um, because it seems to me that the theory would look different at the higher level of abstraction if the answer to that question was one way rather than the other. Um, the friendly addendum is I'm not quite sure your description of the position of the Prime Minister in the UK is correct constitutionally,
Mhm.
although I bow to superior knowledge here if we have constitutional lawyers in the room. I think they get to form a government because they command a majority in the Commons. The political parties, therefore, are, on my understanding, a historically contingent part of that. So it's not conceptually necessary for them to be a member of a political party. And I believe we have had um, prime ministers before who have been parachuted in who are not heads of political parties but could nonetheless command majorities, although my history would need fact checking there. Final question, which is possibly an unfair one because it's so large in scope, but
Great.
food,
That's it.
food for thought. Why not make them charities?
Such a great question. Yeah. What
And that's me. Thanks very much for indulging my long list.
11 out of 10. Couldn't be better. Couldn't be improved. Magnificent as ever. I'm so grateful. Professor Hamid, is it better for me to respond or should we take a group of questions? I want to respect the norms. I'm a big believer in norms.
I mean, we're lawyers, aren't we? So, no, please. I think maybe there's a good list of questions there from Alex. So, if you'd like to,
Okay.
yeah, respond to
Sure.
those, yeah.
Yeah, fabulous questions, Alex, of course. And I'm just so grateful for everything. Maybe I'll work backwards through them. All really tricky. Yeah, absolutely true. Charity is an excellent thought. I'd never thought about that. I'm just going to take that on board. I think that addresses a lot of the campaign finance worries that people like Keith Ewing raise in the terrific book, The Cost of Democracy. Jake Robon's written about this. So I'll look into that. A great suggestion I just had in Canada was to make them trusts or to think about. So there's a lot of literature on this now about Evan Fox Decent at McGill. Lionel Smith has written about this, about the fiduciary properties of politics. And I think there's a lot of juice in that orange too. So I'm thinking about what the but I hadn't thought about charities, but I think that's coming from the same thought. That's the same kind of idea about what kind of group are they. But I love the charity idea because I love the idea that, I think it really captures the conflict of interest worry I had that there has to be some space between that you're acting in the best interests of, in the trust example of the trustees, in the charity, the charitable objects. So I really like that. I think there's a lot of juice there. So I'll be keen to talk to you more about that. On the third point, I think you're absolutely right. And I hadn't updated this paper since Dane Lowe published on the UKCL Leah blog recently a great piece teasing this out. Your very good point about the ways in which it actually doesn't automatically follow that the person, even who commands the largest party, becomes prime minister. So you're absolutely right. So he gives both the examples of the ways in which the space for the sovereign to exercise different prerogatives, but also some of the very good examples that you've raised. So you're right to say even in the piece that's been published, I've been too quick on this. So I need to think harder about what the conceptual link is and whether I still want to call it a conceptual link and whether it's enough to say not it has to be one particular person, but rather to say I form or I am part of a class of people or a very small group of people, or I'm the kind of person that can perform this role because of a particular status, and whether that's enough. And I sort of um I do want to say I think that's still enough, that that's still quite a strong link. and that's enough to justify some kinds of role obligations. And I don't want to put anybody on the spot, but I'm really curious whether people are at all persuaded by this role obligation move. And I don't think I put it too strongly in the paper. I think I can still soften the claim and still keep the role obligation point. So to say, look, I'm a parent who adopts children, for example, so I might not, or I might be, there might be different people who could be classed as the parent of a person, but I'd still have role obligations to that child, for example, or someone might have multiple professors, but they still have the role obligations of pastoral care, something like that. So but I see the thought, and it's absolutely I absolutely need to gloss that differently, and then I need to reckon with the serious philosophical implications of that. And maybe that connects to your first point. So you're right to say I moved too quick between forming the government and then exercising state power. And you're right to say that matters a lot for the questions, which then could be, for example, matters of legal contestation are subject to judicial review. So let's imagine it is unclear who can form the largest party and someone judicially reviews that decision, right? That it really matters a lot where I want to put the pressure there. So maybe responding to your third point is a way to connect to the second point and say, look, it's not the forming of the government that matters, and I need to give up some of that to avoid hostages to fortune, maybe, because then I'm gonna open myself up to other non-justiciable challenges to prerogative, something like that. So that's a great thought. The Desiderata point is hard. The Dresda point is hard. I think, and I wonder whether bringing in the rule of law does more harm than good. But I felt like the paper didn't have enough of a through line, and maybe, and it did feel to me like what mattered about the limits I was putting forward were that they were rule of law-ish. So that suggests I'm committed more to your second point, not that there's something logically about the rule of law that requires, as you say, because I don't want to get into debates about what the rule of law requires, but I do think that there are conceptual limits on the exercise of state power. But I think then you're right, that's very helpful, because then what I'm going to have to tease out more particularly is what it is the political parties are doing that puts threats or raises the possibility that they're exercising power without limits. And so I'm going to have to dig harder maybe into this conflict of interest point. So that's extremely helpful, and I'm really grateful. And I'm going to need to both rephrase that, tease it out. But yeah, I liked the way you put it in the second, which was they were something like requirements of the rule of law which apply to parties, not something like that, not and maybe I need to drop the rule of law together. I'd be grateful to hear people's thoughts about that if they've got strong views, if they're not persuaded, or if they are persuaded. But that's absolutely fabulous, Alex. You're a super genius. 11 out of 10. I'm so grateful.
Great, great, thank you. So I have a couple of questions also, and just to pick up actually on what you were just saying, Leah. So if do you still have the PDF open of
Yes, of
the
course. That'd be so great.
so
Fabulous.
so
Let's do it.
so just to jump to the very
Let's do
first
it.
page in the title. So
Yeah.
I suppose my puzzle was about the title of the
Yeah.
paper, and so picking up on this point about the rule of law, the
Yeah.
title, and then what I thought the thrust of what you were arguing in the paper was. So I suppose if we accept that if we're pluralists about political morality. So, we think that there are various ideals of political morality. One is, democracy, the democratic ideal. One is the rule of law. One is justice, and so on. I wonder, or my query is, actually, are you concerned here with issues about how political parties can best serve the democratic ideal? That's
Mm,
actually the thrust of what, and I think at times you're sort of hinting at this.
yeah.
That's actually your concern because you're talking
Yeah.
in the paper, in the substance of the paper, about democratic contestation. You're worried about, a political party monopolizing
Yeah.
public power and so on. So your concern is, what are the requirements of the democratic ideal, and
Yeah.
how can political parties best serve or fulfill that? And then, if it's the case that we might want to have legal standards in play to regulate this. And of course, that's where the rule of law comes in, because then we'll say, okay, these agents, these actors, political parties are subject now to legal standards. They should be rule of law compliance and so on. But in a sense, that's subsidiary, right? And the what is motivating this, what limits we should even have in the first place, whether legal or otherwise, that's about the democratic ideal. And so that's the thrust of this. And if that's the case, then we'd want to figure out, okay, exactly what is it about the ideal of democracy that is required here, which is a very sort of thorny issue. Alternatively, if you actually do think that the rule of law as an ideal of political morality, desiderata of the rule of law, actually does motivate certain specific requirements here, legal requirements, then exactly how? What are those? So I suppose that's my one sort of big question. And then the other question I would just ask is, I suppose you're thinking comparatively. One example that springs to mind, South Africa with the ANC, which post-apartheid has sort of dominated the political landscape. So I wondered, just looking comparatively, are there lessons that we can learn from some of these jurisdictions which are constitutional democracies, but where one party is or seems to be dominating? Thank you.
Fabulous questions. Asif, tremendous. So I can tell you how helpful that is. Thank you so much. I think it's so helpful. I think you've absolutely rightly identified this ambivalence in the paper. Because if I can be honest, I think I myself am pretty relaxed about, in my own view of this, I feel pretty strongly that this is the least political parties can do. And I'm pretty relaxed about them having to justify their internal processes to judges and to be transparent about that. But I feel, like I'm sort of, I'm pushing so much, it feels sometimes against orthodoxy. And the reception I get is usually so concerned about undermining democratic contestation and unintended consequences. So that's just sort of my own autobiographical so it's tricky in writing a paper when I think there's a gap between what I actually think and and I think your point is so helpful because it's really captured, as you absolutely rightly say. On the one hand, I say, look, nothing to worry about here, nothing too challenging. Legal limits are light touch, right? Backstop, shore up democratic contestation. But I think you're right to say, I feel this really strong capital P pull of the exercise of state power and what the implications of that are. And I think you must be right that the title isn't actually what I mean. Or that might be what I think, but that's not what I say. And you're right to say that isn't right. And I need to think, I think that's a really nice way of helping me respond to Alex and saying, actually, these aren't about requirements of the rule of law itself. It's more about, this point about democratic authority cannot be legitimately exercised without limits. And actually, the rule of law is a distraction from that. And actually, it's bringing that in is going to open me up to the kinds of questions Alex has rightly identified. So I need to make peace with the fact that, it's too the risks of unintended consequences people think are so great from saying, so the example that reviewers always give me is Sunni Ittihad Council and Pakistan Electoral Commission, where you've got quotas for different political parties, and then these become sort of tools of legal contestation, which are thought to undermine the process as a whole. So that's an example that I'm often given of the risks of my kinds of approach, which I'm probably too relaxed about, because I think there are risks that either way, there are risks of not having having quotas for those constituencies. But it's a fabulous point, and I think what I'm gonna have to do is recast, as you say, the rule of law as a piece of but I'm gonna need to think about the pluralism point, and I'm gonna need to then do some work to bracket and clarify the claims. So that's super helpful. The ANC point is tremendous. That's an outstanding point. And a really hard example for me to think about what exactly I mean by the monopolization of power, where you've got complete party dominance, over decades, and then the meaningful political contestation is within the party. It's not in the, in the elections as a whole. So you're right to say that's a hard example for me to think about I need to really sharpen my language and to not be caught up in that, but also to think about. But I think it's also a really powerful example of I wrestle with how much to use. I think there are lessons of competition law to bear on election law, and I'm worried about something like abuse of market position, but I don't want to go down the Exacaroff politics as markets. I don't want to go down that role completely, but I am worried about something like conflict of interest, abuse of market position. So I think thinking about the ANC example is really going to help me tease out what exactly is the worry here about competition and how do we protect it? And maybe I don't know enough about South Africa to know, but maybe there are ways that the fourth branch institutions have evolved to then protect some of the contestation, even in, or maybe perhaps not, in light of this party dominance. So that's a terrific example for thinking about the AgMom piece and competition. So those are tremendous points. I'm really, really grateful. Although I can feel like as I've cut through the noise of the paper to see the core, and I'm very grateful.
Thank you, Leah. Absolutely fascinating. So I just noticed Alex has a point that he's just mentioned in the chat. I don't know, Alex, if you want to just say something about that,
Yeah,
or
let's do it. Let's do it.
or
Yeah,
yeah,
yeah, sure. I
yeah,
mean, if we have time, it was just that on
sure.
the pluralism point, I mean, hands up here, I am, well, a sort of value pluralist when it comes to these sorts of things. I'm a holist in the Dawkinian sense, so somewhere in between the two. But I wonder if, because I mean, there is a sense in which democracy and the rule of law meet, and there's a fuzzy sort of constitutional area in which they do. And it seems to me, and I was really interested about this actually, because it seems to me that you're making a constitutionalism point here, which I'm not sure how attractive it is to you to put the point in precisely those terms, because so much groundwork in your last book is trying to put discussions of constitutionalism as a sort of separate domain to one side. And I wonder whether, because the formation of governments in which the regulation of political parties, has such a predominant role, whether that can be avoided.
Yeah.
Um,
Yeah.
but here I'm sort of drifting into kind of a Rentian understanding, I guess, of
Yeah.
power rather than power in the potency sense. But
Yeah. Yeah. It's such a great question, Alex. It's too clever a question for me to totally reckon with it. But I'm going to use the opportunity to say, the something about, what Alex rightly says about my book and what I'm not persuaded by, and then the way in which. So I've just written a book. Well, just there I've written a book about referendums, and the sort of key move there is to say I'm really not persuaded that there are some decisions that representatives just can't make about conceptually, about, for example, secession or devolution or joining supranational organizations. I'm not persuaded that we delegate power to representatives in a social contract kind of way, and that then they can only exercise that for a limit. I'm not persuaded, as Alex says, I push back on that vision of delegation with limits. And the way in which this paper is different is, I think, but what I am persuaded about is to say, if there's a conflict of interest argument, that I do think that's a case in which representatives, there's some decisions they can't legitimately make. And I don't think it's legitimate for political parties to say, well, we think we're going to institute these voter ID laws, which we have, the Electoral Commission tells us we think will disenfranchise certain kinds of people. I don't think that's a legitimate exercise um, of state power. So I haven't teased that piece out enough, but Alex is right to say, there's then he's absolutely right to say it's hard to know how much we can say about political parties in particular without saying, look, and this is what constitutional democracy requires in general. It's very, 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 very difficult. This is just a challenge for all of you brilliant folks writing or thinking and studying in legal and political theory. Alex used to tell me everything's connected to everything. That's what makes this hard. It's absolutely true. Everything's connected to everything. So So what I think, so I decided in the end I wasn't going to write about that sort of ultra vires piece, but for a different reason. But maybe I do, and maybe that's the link that you and Asif are inviting me to tease out. Maybe that's the link here. Maybe that's what's doing the work, is this idea that this conflict of interest point is contrary to democratic contestation. And maybe that's what's, Asif's rightly saying, what's actually driving this? Maybe that's what's driving it. And it's not the rule of law. It's a kind of conflict of interest, ultra vires thought. Um, but you gotta, but huge. I'll send Alex's commission later. You got for plugging the book. You gotta get always be selling. It's one of the rules. So, and I wanted to say too, I don't thrive in big group settings with lots of super clever people like this one. So if you've got questions about it, or you're thinking about writing about it, or you're thinking about any of this, feel free to drop me an email. We can set up a chat sometime. Don't feel like if you've got questions, you have to ask them in this massive group if that's not where you feel most able to do your best work.
Great. Thank you. Thank you, Leah. I'm sorry to say we have to pause here.
Oh
So
yes,
we have to,
yeah.
yeah, we have to unfortunately end the seminar at this. But thank you so much to Dr.
Oh,
Leah Trueblood for such a fascinating talk. And I think this is a really central issue. There's more attention being paid now to political parties, but it's just such a central issue that we need to think about. So thank you very much to Leah. Thank you to all of you